Hi, Frank Morris, back with some good tips on how to build and manage your practice. The first rule for all family law lawyers is do not work for clients that have no money in your trust account to pay for that work. Working for clients who do not have money in your trust account is the exact same thing as loaning money to that client. You know approximately what a case is going to cost when you enter into the contract with a new client. Yes, there's going to be exceptions, surprises, cases that do not go as planned, but for the most part, we know the general fee range for all of our new cases. Require a reasonable advance fee deposit up front. Don't get started behind the 8 ball. If the client will not or cannot provide a solid advance fee deposit up front, how are they going to pay for the work in the future? How are they going to continue to pay for work as the case progresses? Do not take on clients that obviously cannot afford you. Monitor each case closely. Monitor the upcoming work and estimate the upcoming costs. Request that the trust fund be replenished well in advance of doing the additional work for those clients so that your clients will have an adequate time to make a deposit in a reasonably business-like manner. Do not wait until the last minute to request additional funds. That will only cause more stress for everyone. At the conclusion of the case, it's better to give a client a refund of the balance of funds held in trust than to hope that client will pay you for the work that you've already performed. The truth is, it's easier to work for a client without funds in trust. We are trained and committed to providing legal services. That's what we do. But if we do not collect funds from those that we're providing services to, we'll go broke. We'll go out of business. Then we cannot provide good legal services to future clients who are willing and able to pay for those services. Managing your client's trust funds is a matter of self-training. It takes consistent effort. You must always check that there are funds in trust to pay for all the upcoming work. Check before, not after you have performed the work. It's easier to request funds in advance than to request funds after the work has been performed. Not insisting on clients maintaining adequate funds in their trust account for future work is a slippery slope. The bigger you allow the arrearage to grow, the harder it will be for the client to bring their account current. Once your client owes a large balance, it's always easy for that client to say that your work was inadequate, and that's why they're not going to pay you the balance that is owed to you. If you are providing good legal services, you deserve to be paid for that work. It's your job to manage the trust funds for your client. Maintaining sufficient funds in trust to pay for upcoming work will lead to a better attorney-client relationship. So the first rule is no money in trust equals no work.